focusing on the Labour Party petition, the article petition is also there. If there is need to make reference to them, because the grounds of the petitions are similar, even though there are certain areas of peculiarities. One, they are contending that Tinubu did not score majority of lawful vote cast. Recall I explained what lawful vote cast is.
Yeah.
Secondly, that Tinubu, at the time of the election, was not qualified. Thirdly, they are saying that Tinubu did not, he was not qualified for the election. He did not score majority of lawful votes. And yes, thirdly, that the election is invalid by reason of non-compliance with the provisions of the Electoral Act.
Mm-hmm.
Right?
Yes.
Now, what is the issues, or what are the issues they have raised upon which these very interesting grounds are predicated? Right? I will start with the first one, majority of lawful votes cast. And permit me to say that the petition is about 100 pages. So I'm not going to speak to every page of the petition. I will just speak broadly about the issues therein. One, they are saying that Tinubu's vote is not lawful because he has not satisfied certain prerequisites, including the one enshrined in section 134 of the Constitution regarding geographical spread. Because under the Constitution, you have to show that you have scored 25% votes in 2/3 of the states and the FCT. The argument of the petitioners, Peter Obi and Labour Party, is that Tinubu did not score 25% votes in the FCT, as enjoined by section 134 of the Constitution, and therefore ought not to have been declared. And the argument is based on the school of thought, the jurisprudence, that for the purpose of election, that provision of section 134 has to be read disjunctively. In other words, that the requirement of 25% votes in 2/3 of the states is separable, distinct, different, and independent of the requirement of 25% votes in the FCT. This is their argument. This is what they are contending. However, whether that argument is going to hold up at the court will be based on several things, but ultimately will be the decision of the Court of Appeal to make. But that is what their petition is saying. So they have argued that for the purpose of the election, Tinubu should not have been declared. The other species of majority of lawful votes, which the petitioners are saying the second and third respondents, Tinubu and the APC, did not meet, is that they have also contended that the votes ascribed, counted, and declared for the second and third respondents, Tinubu and the APC, that those votes are not true reflective. They are not reflective of the actual vote cast. In other words, Peter Obi has contended that in certain states, and he has isolated about 9 states for the purpose of his petition, including Lagos, Port Harcourt, Plateau, and some other states, where he has highlighted the results based on the Form ECH series, or particularly from ECH. From ECH is the polling unit result. And he's saying that on the basis of the results as counted, recorded on the polling unit results, that the votes that he had were seemingly ostensibly declared by INEC in those disputed states does not reflect the actual vote cast. Again, take your mind to what I said was lawful votes. So he's saying that in Lagos, for example, that the votes recorded for him, and the same argument that been made for Rivers, was far lower than what he actually scored. And that if the cumulative lawful votes cast for him is computed, and the unlawful votes recorded and declared for Tinubu are excluded, that he ought to be the one who should have been returned elected. Now, the second ground of the petition is the argument that the candidate of the APC, the Bola Ahmed Tinubu was not qualified to contest the election, right? And what is the indices of disqualification that the petitioners are canvassing? The indices of disqualification is primarily on the question of Tinubu's link to drugs in the United States, right? The Special Agent Musk investigation, which crystallized in a forfeiture order, recorded, incidented, and documented in the US. And we have seen certified copies of documents that speaks to this. The evidential value of those documents is a matter for the courts to determine. And secondly, the implications and the applicability of those documents or the contents thereof in relation to our election, it is also a matter for the Court of Appeal to determine. But for the petitioners, on the basis of their Tinubu's forfeiture of monies to the US government, you ought to have been disqualified. And that is based on Section 137 of the Constitution. I'll just read subsection D. It says, he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, This can be construed to mean by any court or tribunal, not necessarily in Nigeria.
In Nigeria, okay.
Clear that the sentence of death has to be imposed on a court or tribunal in Nigeria. That is imprisonment or fine involving dishonesty or fraud by whatever name, or for any offense imposed on him by any court. Again, lawyers will make a whole lot of arguments about this. When the thing about the law is that why lawyers like to pride themselves as learned, this provision says it all. Why lawyers carry that pride, we are learned. Whether it is a valid pride or not is a different matter entirely. But when you look at this section, as someone who is educated, you can give a meaning because you are reading it, you are reading the English in the provision, but the lawyers are not looking at the English, the grammar. The lawyers are looking more deeply into the meaning within the legal context of the words used. For example, if this provision on the face of it, you can say that the conviction or sentence has to be one that is imposed by a court in Nigeria. But the other argument is, if we look at it, it looks like what is contemplated envisages one that is imposed by any court or tribunal, whether in Nigeria or elsewhere, or substituted by a competent authority for any other sentence imposed on it by such court or tribunal. I believe this is the basis for the argument about Tinubu's eligibility. It will now be for the court in Nigeria to determine the consequence in law of the forfeiture, whether that forfeiture can be elevated to the status of conviction or a sentence or criminal sanction. I'm aware there are Supreme Court decisions on this point. I have reviewed some of them. I will not speak so much into them, right? Because I mean, the petition is there for the lawyers to argue. But I just needed to have a background. Now, that is the argument. The Chicago University thing, I haven't seen that in the petition, just to clarify. The question of Tinubu's academic qualification is not part of Peter Obi's petition. I haven't seen that. I have not seen that part of that issue in Peter Obi's petition. I have not seen, I'm still reviewing it for now. I haven't seen that. So the question of disqualification is primarily premised on the forfeiture, which for me, I'm very interested in seeing how the Nigerian court is going to approach that.